Good morning. Stan Stahl with SecureTheVillage here for the April webinar. We're starting a three-part series on the California Consumer Privacy Act this month, May and June as well. We're very pleased this month to have as our sponsors the Pepperdine Graziodio Business School and their very innovative cyber risk certificate program, and of course my company Citadel Information Group as well. We've got a really excellent, superb panel of 3 attorneys and an insurance expert. Attorneys Tim Toohey. He's a privacy expert with Greenberg, Glusker, Fields, Claman, and Machtinger. Bob Braun, who is an attorney with Jeffrey Mangels, Butler, and Mitchell. Tom Peistrup, who's general counsel of InStyler, Trey Milano, and also a member of the Secure the Village Board of Directors. And representing the insurance industry is Howard Miller, who's vice president, director of the technology division of LBW Insurance and Financial Services, and also on the board of Secure the Village. Why don't you each say hello, and we'll get this webinar going.
Hi.
Hello.
Yeah. Who will speak first? Bob Braun from Jeffrey Mangels. Good to meet you.
Yeah. Hi, Bob, Tom, everybody. Yeah. So there you have it. If you're watching us live, you've heard a hello from everybody, and here's what we're going to be talking about today. I mean, there's a whole big set of topics of CCPA. Who's covered? What does it mean? What are the business obligations? How does it relate to GDPR and all the other privacy stuff that's going on? What's the Attorney General's role? Blah, 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 blah. All focused around kind of 3 real issues that we want to talk about. First of all, what is CCPA? How did it get here? Where is it going? What does it say to the extent that that's clear? And you'll hear in a few moments that there's a ton of ambiguity even in the way the law is written. Most importantly, and this is where we're going to spend the bulk of our time, what are the business challenges? So you're in a business, you run a business. What does CCPA mean to you? And then given that, what do you do about it? How do you manage what we're going to see as we go forward? Is that there's a ton of uncertainty, which means there's a ton of risk in CCPA. And so what's a prudent business to do in dealing with the California Consumer Privacy Act? So with that, let's just jump in. Tim, why don't you lead us off? Quick little overview of what the California Consumer Privacy Act says.
Well, I think even before that, I'd say that this is a very revolutionary privacy act for the United States, and so it's going to have a great effect. Already it has an effect on other states. This was passed last year to forestall an initiative that would have been put before the voters, and it is a statute that is currently being revised as well as debated. But as it stands now, starting January 1st of 2020, consumers, which is a very broad category, which includes California residents and it can include employees, children, and parents, will have certain rights to disclosure to request categories and pieces of information collected about them from businesses. They'll have a right of deletion, something like a mini right to be forgotten, similar to the GDPR, to have certain information deleted. And they will have rights, I think importantly, to opt out of sharing of their information, including a prominent button to be placed on websites that they can explicitly opt out of the share of information, and rights to be compensated in events of data breaches, including private right of action. So this is providing really a kind of consumer bill of rights that is never been seen in California before.
Cool. Tom, you want to talk a bit about who this applies to?
Well, it applies. I think that the term consumer is a little bit of a misnomer. It's people and we really need to be thinking about this more in terms of residents as opposed to consumer. So it applies to everyone in California who's in California for non-transitory purposes, or any Californian who's in some other place for transitory purposes. That's whom it applies to. in terms of who's protected under the statute.
Right. Bob, you want to jump in a bit on kind of, well, all right, does this apply to all businesses? Some
No,
businesses?
It's also important to know that this can have a ripple effect, and it can extend really beyond the normal concept of what the privacy has when it includes employees, which is something that can be used by attorneys in connection with employment litigation and may be used by employees themselves. So it's very broad. It isn't perhaps as broad as the GDPR, which is comprehensive privacy rule for at least current count, I think 27 member states of the European Union. But for the United States, this really provides consumers, as Tom said, in a broad definition, with rights that they never had before, and I would say rights that are increasingly in the news and are being the subject of debate. I mean, even today, I see Facebook has shared the personal information of a lot more people than it's originally thought. So this is something that's very timely. It's something that has really been called for by consumer advocates for many years, but it's going to have very significant effects because of the range of businesses that are subject to this. As you'll see on the screen there, it relates to businesses that have gross revenues greater than 25 million or obtains personal information of 50,000 or more consumers, households, or devices annually. Notice that expands even beyond consumers, or derives 50% or more of annual revenues from the selling. This is a very broad definition, and businesses are going to have to modify their policies and procedures. Many businesses are, because 50,000 or more consumers, households, or devices is not all that many. So this has a very broad impact and will be likely affect the policies that companies have to do, not just in California, but beyond California.
Yeah.
Well, it's very clear that it covers businesses outside of California, because the key is that it impacts California consumers. I think one other unintended effect of this is that, like a lot of laws, and these include not just privacy laws, but securities laws and other consumer protection laws, is that in order to implement this, as we'll talk about later, a company that is covered, one of the 500,000 or so companies that is covered, is going to be looking at its partners, its vendors, its suppliers, and others, and is going to have to include them in these requirements. So it's likely there'll be a waterfall effect on far more than the base 500,000 or so companies that are directly affected, throughout the country, that are affected by the law or are subject to the law.
Yeah, Howard, you were going to jump in and.
No, that's a great point. There's a flow down here, and we're all connected in the same way that a business associate is connected through comparably HIPAA.
Right. Yeah. Yeah, I see that. Just the work that we do, our company does in helping our clients just navigate through and manage the security of their information. That flow down is already having a profound effect on just raising the bar, if you will, for security. That, as you mentioned with HIPAA, the BAA, and we're seeing clients that are being audited by their clients that way, and as you say, this Bob, this adds to that whole flow down, which, I mean, as a consumer, I think that's a great thing. I'm very happy to see that. Yeah, go ahead.
I think there's another. This is going to be an issue that is going to create a lot of consumer fatigue. In the same way that the breach laws have created consumer fatigue, and that consumers now don't really take breaches all that seriously. Another breach. So another 500 million pieces of unencrypted clear information provided by Facebook. Old news, things like that. People are going to be inundated with information about the disclosures and things like that. And, I have a feeling that consumers just may not take it all that seriously. Because after all, it's just one other piece.
I guess I would disagree. If I faded out there for a moment, I apologize.
But go ahead.
But because I think that this is something that consumers have been clamoring for, perhaps not the majority of them, it'll give them affirmative rights as opposed to sort of passive disclosures. So I think it will, I guess, prove whether, though, the privacy advocates really are correct in saying that this is something that consumers are concerned about, because we constantly are seeing that with breaches such as the recent Facebook breaches and the others, that consumers are up in arms, or at least their organizations are up in arms. Now, if no one requests information about themselves, that may be different, but it's certainly proved in the GDPR in the first months of its coming into existence that many consumers are making precisely those sorts of requests, and there have been numerous complaints to the data protection authorities there. So I think I'm a little bit more sanguine that this is going to be a burden or a potential burden, and even if it isn't, businesses have to prepare to be able to make such disclosures and to accede to consumer requests, which could be very onerous depending on the type of business involved.
Well, it's certainly going to be a benefit that's going to be realized by my brethren in the class action bar. So, we'll figure that out.
Oh, yeah. Yeah. Now, I'm expecting, and Tom, maybe you'll jump in as well, what your expectations are, but, come January 2nd, first day back to work, AT&T, Verizon, the major internet service providers, Time Warner Cable, et cetera, are going to have requests for disclosure from consumers of some group or whatever. What are your thoughts?
Well, there's certainly going to be demands. The CCPA provides four basic rights, and one of them is to consumers, and one of them is for consumers to know on a very general basis, which is on a disclosure on the website, but also on a particularized basis. That is a request of what kind of personal information is maintained by a business about them. And so that comes about through a request. And I imagine, like you said, on January 1st, there are going to be a lot of requests going out. There's also a look back portion of this statute. So even though it doesn't take effect until January 1st, 2020, it's really in effect now in some respects, in that you have to provide 12 months of data going back.
Yeah. Yeah, and that 12 months we're seeing again on our side as we're helping clients get ready for CCPA, that having the, and we'll talk more about the data inventory and all, being able to know what information you got about somebody so that you're in a position to disclose it should they ask you for it. In the next couple of minutes, before we go on to the next slide, I want to talk about the bottom left and the bottom right, because these are absolutely new. The right to be compensated in the event of a data breach. All of you have talked to me before in the past about that in order to realize compensation for, let's say, a breach, you have to prove that you have been damaged, that you have been harmed. And this would seem to say that's no longer the case. Who wants to jump in and be the first to talk about this statutory right to be compensated?
Got to fund the courts. Got to fund the court system to handle this. That's all.
Well, yeah, this is particularly, I know, sort of jumping ahead, but this is particularly interesting topic because there's been a proposal, as we'll discuss on the next slide, to expand the private right of action. The frustration has already been, and here I represent both plaintiffs and defendants in security breach matters, is that plaintiffs who genuinely feel that they have had their personal information exposed and are vulnerable and feel essentially naked to the world because of the compromise of personal information, have not been able to get sufficient compensation from companies that have had lax security practices. So what's interesting is that this private right of action, as it now stands before it is potentially expanded, is something that we've not seen before because it provides statutory damages without the necessity of individualized proof, monetary proof. But the thing is, and I'll let someone else sort of explain this, it relates back to an earlier statute which has been on the books for some years that has a fairly narrow definition of personally identifiable information, not the broad definition of personal information that the new statute has.
So Bob, does this change that fatigue? Is this going to impact that?
Oh, no, I get. Look, I don't want to be too glib about it. I think, but I do think that again, the class action bar is tremendously vigorous and fully ready to handle these issues. I think it's interesting because uh, it's because I think every time that there is a data breach, we go through our clients and talk about what has to be disclosed and things like that. And this really changes the landscape because of the definition of personal information, which is now really any information which can identify someone. And before, a lot of time, if a client chose to, they could walk between the raindrops and say, well, we didn't fall within the exact nature of the statute. So my question to you, Howard, is
Yeah.
are you guys going to have product which is going to cover this kind of breach? As as in the same way that you're sort of covering the current breach scene.
Yeah, and that we already have product that covers this, but I've kind of gone through my 5 stages of grief with this, as Tom would put it. But here's my thought. So when you actually read this AB 375 Section 2C, at the same time, California is one of the world's leaders in the development of new technologies and related industries. Yet the proliferation of personal information has limited Californians' ability to properly protect and safeguard their privacy. So we have technology advancement, certainly in California, and we have availability over confidentiality and integrity. So these are some of the issues I'm getting out of reading this California Consumer Privacy Act. It goes on to say it is almost impossible to apply for a job, raise a child, drive a car, or make an appointment without sharing personal information. And I think this gets to the principle of need to know. So when someone asks you to prove your age and you give them your driver's license, now you've given them your address, your driver's license number, and a number of other information. And so I think this is getting at controlling the amount of information on a need-to-know basis. And then it goes on and says, as a role of technology and data in the everyday lives of consumers increases, there is an increase in the amount of personal information shared by consumers with businesses. And I think this touches on the growing interconnected system that we have, including third parties. We talked about that a minute ago. I think it also extends to the Internet of Things. And all of this kind of came out and I think was prompted by the data breach, of which I would call it, with Facebook and Cambridge Analytica, where we started to realize, well, it's not just my personal information, but now I can be connected to groups that have affiliations politically, my family members, things of that nature. And then finally, I would say it says that California law has not kept pace with these developments and the personal privacy implications surrounding the collection, use, and protection of personal information. So now we have a need to advance the law and a need for technology to help us manage this. And these 3 words are critical. So you have collection, use, and protection. When you're looking at cyber insurance, there's kind of two sister areas. One is, privacy injury and network security. And you have to look for language that's going to address the wrongful collection of information. Use, whether that's misuse or someone who has authorization that goes beyond the means of their authorization, such as in a hospital where you have maybe a nurse looking at records that they shouldn't be viewing. And then the protection of that personal information, where you start to get into network security. And if you're a third party in this flow down and you're the cause of that breach to a company that falls under the CCPA, that you're going to need to be able to address that and defend yourself. So the other aspect is the regulatory defense and fines and penalty, which is already fairly broad. Now, how that's going to play out with the amount of lawsuits that we see with the insurance industry, I'm not sure. But if you add up all of this, what you get is partly cloudy. And I think when you're in a partly cloudy environment, that's a really good place for insurance. And I think that in some senses, the law is starting to outpace technology, where technology really needs to pin down control over this information. And that would be interesting for Stan to comment on that.
Well, I think, Howard, part of what you're saying is you've got the technology, but then I look at this right to be compensated, and again, the qualifying thing that qualifies this compensation right is that the consumer has the right to be compensated unless the business has, quote, reasonable security procedures and practices appropriate to the nature of the information being protected.
Correct.
And that clause, I mean, that's where the meat in this right to be compensated kind of lives. What does it mean? And this is the whole subject of the third of the CCPA webinars. What does it mean to have reasonable security procedures and practices? And I contend that's not a technology matter, that's a management and leadership matter, which, as defense of what I just said, I simply suggest that everybody go back and watch certainly the first 12 of the webinars that SecureTheVillage has put together over the last year and a fraction right now. Tom, before we go on to this, you've been kind of quiet the last couple of minutes. I want to give you a chance to finish up, and then we're going to go to the next slide.
There are a couple of things I want to point out. First of all, although the CCPA defines personal information incredibly broadly as a general matter, and it has, I believe, 11 categories, it even covers how a consumer smells, believe it or not. So if someone smells like cheese, that's protected. But when we get to the data breach section, it's a different kettle of fish. Because it actually imputes a different definition of personal information. It's a much narrower definition, and that is significant. That being said, the fact that a consumer is not really a consumer in the general sense means we need to be thinking about this in an HR context as well, and in other contexts in which you may have personal information of another person. And the data breach section is the only section that has a private right of action. So I think it might be helpful to take a look at that section in particular. Are we ready for that?
Well, we're not going to go into the specifics of that. Okay. That's a deep dive that we're just not able to do in an hour-long presentation. So if you want to maybe summarize just what that is before we do move on, because this again, we've begun touching the ambiguities in this situation. So,
let me summarize. It's section. Let me find the section. It's 1798.150, and it provides that a consumer use non-encrypted or non-redacted personal information as defined in, and it refers to a different section. And if that information has been compromised, then that person has a right to institute a civil action under certain circumstances. That's what we're talking about, the right, when you talked about the right to be compensated in terms of actual damages or statutory damages. However, there is a cure provision in there as well. As we know from other consumer protection statutes in California, cure provisions are typically, the plaintiff's lawyer will typically write his demand letter in such a way that it's impossible to cure. But I think that based upon the definition of personal information that we have in the narrower definition, it may be possible to have a cure in this circumstance.
Mm-hmm. Okay. Hey, let's take that and move on to the next section, because again, it's ultimately continues the whole discussion we've been having. It just focuses it. I mean, you've already talked about, if you will, these ambiguities and uncertainties around what counts as PII. But I think the bottom line is the heading on this slide. CCPA is revolutionary. It is incredibly ambiguous, which is something attorneys, insurance people, I'm a trained mathematician. Ambiguities are deadly. We want to get precision. There's large uncertainty, and when there's large uncertainty, there's also high risk. And this is the world that your clients, our clients, are now having to navigate through. So let's spend the next, it'll be a chunk of time, pretty much running through what some of these things are, starting with the ambiguities and uncertainties that we've already been talking about. So, who wants to kind of jump in and start this one? Go, Tim.
Yeah, the personal information, I embrace ambiguities. I have a much more healthy love of ambiguity, I think. I don't know. But maybe this will test it. But personal information is information that identifies, relates to, describes, or is capable of being associated with, or could reasonably be linked directly or indirectly to a particular consumer or household. So strike the term PII. Bury it. It is personal information now, as defined under this statute. It's not the same as that Tom just mentioned. So there's an ambiguity based in that term. It is a broad definition like that of the GDPR that is meant to take into account evolving technology and not sort of related to specific pieces of information, which we can still argue about what is PII under the data breach statute, but this is going to be even broader, and it's going to really delve much more deeply into evolving technology. So that, I think, is one of the biggest uncertainties, is how we're going to deal with that. Now, if it happens that, the other thing I'll mention again is that this statute is not necessarily written in stone as of this day in April 2019. It is being debated. There are bills to expand it, and there are bills that want to expand the the private right of action to any statutory obligations under this law. So keep in mind that what we say today may be subject to considerable change, and the fact that we have a very broad definition of personal information, a modern definition, I would say, is one that's going to cause a lot of heartache and uncertainty.
Let me just touch on that really briefly, because Tim is right that the CCPA defines personal information incredibly broadly. And as Tim noted, it is currently, there's a Senate bill, I think it's 561. It was proposed by the Attorney General and a senator, I can't remember which senator, and it's currently in committee. I think it's going to be voted on. It's past the first stage. It's going to be voted on in just the next few days. And it is possible that amendment will become law. It would expand the private right of action to any statutory breach, any breach of the CCPA. But that's not the law right now. And in terms of data breach specifically imputes a different definition of personal information. It's a much narrower definition. So I just want to distinguish between, in the statute, there are at least two definitions of personal information. And the one that I'm talking about when I talk about the narrower definition, that's for data breach, and that's the only part of the law that provides for a private right of action.
Should we be getting ahead of this and err on the side of the broader definition contained in personal information, as Tim was talking about?
I think a lot of companies are already making that decision. How many times does a company have a breach and we say, well, it technically doesn't cover, but do you want to deal with the fallout if it becomes public that there was a breach which included biometric information, all sorts of things that aren't covered in that specific definition? Tom's absolutely right. It's a more narrow definition, but a lot of companies are simply going to have to are going to say, we ought to get ahead of this because somebody's going to find out. And I don't think the public is I think, despite my belief or my concept of the public, of the public and how tired they are of all this stuff, I think that they look at personal information as something broader that's reflected in this agreement. And I think a lot of companies are making that decision anyway. So why not get ahead of it?
Plus, we have the Attorney General right now written into the statute as the enforcer of it. So no matter what happens, if they don't doesn't turn out to be a new private right of action, companies still may be subject to actions by the Attorney General. Eventually they have to write regulations and the like, but that could also be something that's going to be insurable as opposed to complying with consumer requests.
And there's some fines and penalties there, right? I mean, is it
Yes.
2,500 or 7,500?
Yeah, there are definitely fines and penalties written into the statute, so that the Attorney General has staffed up. At least they've hired some new people to deal with this, and so we may see actual enforcement actions unless the Attorney General would like the enforcement taken over a private right of actions, I'm told, or I've heard. But right now you're going to see enforcement actions of one sort or another related to the whole statute.
What do you think a company could expect in the form of how severe could these penalties or enforcement actions be by the AG?
Well, I don't think they're going to be as severe as potentially under the GDPR, which has a very high percentage of the net worth of a company. And that's really a difficult question. There have been no regulations written. There, of course, will not be any statutory, enforcement actions until at least mid-year next year, if at all next year. So it's going to be very hard to say. The Attorney General in the past has said that privacy and security are priorities, but we haven't seen a lot in the way of enforcement actions. I think under the current Attorney General, there were certainly some under Kamala Harris. But that's a very hard thing to predict. That's one of the biggest uncertainties here.
Mm-hmm. What about, we've got on the slides here 2 bullets just by themselves, no sub-bullets, which is not to suggest that they're small matters. What we've talked about, unintended consequences of this law and the collateral effects as well.
So I'll jump in on one thing. There's an issue with the structure of the statute, which I think is, as Tim pointed out earlier, has a lot to do with the speed and the effect, how it was developed. I mean, GDPR took years and years and years to develop, and people still don't quite know what it means. There are a lot of assumptions in the statute as to the relationship between a company, a business, and a consumer. And one of them is that there is, in fact, a relationship. However, personal information includes information where there does not have to be a relationship. For example, biometric information. So we're in a world where people are collecting pictures and they are collecting sounds, and I think, I don't know if it was Tom or Tim pointed out smells and things like that. All of that is potentially personal information. How can you possibly inform someone effectively when we have no relationship of what you're collecting, what you're using for, and how can you respond to someone who doesn't have a relationship? You just don't know. You don't know how it does. I have another example, but I'll just throw that one out because I have a lot of clients for whom that's an issue, and we are, we're basically, well, we'll come up with something. But it's a tough one.
Right. Yeah.
I have a quick comment in terms of what I think is a big hidden bomb here, and I think that's the HR department. I think that's something that companies aren't thinking about in terms of CCPA, and that's something that you should definitely be concerned about in terms of data breach, which is, again, where you have the private right of action as the law currently stands. And then there's one thing that's not entirely clear to me, and Tim might be able to help us out on that, and that's the service providers and third parties, which in some ways are almost, there's almost an elision between the two, and in the way the statute is written in places. And there is I'm not really clear on how indemnification works in that context. And Tim, could you help us out with that a little bit?
Well, I don't know if I have the final answer. One of the things that makes this really quite complicated is because a lot of the rights relate to what's called the sale of personal data, but sale is very, very broadly defined as releasing, disclosing, disseminating, making available, transferring, or otherwise communicating the consumer's personal information. So as Bob said, here we don't have the differences between controllers and processors, which are embedded into the GDPR, which then mean that you have to have processing addenda from vendors who then get the information to process it. But we have essentially a definition of sale, which is as broad as the definition of processors. So this is going to further complicate the already very complicated issue of how a company deals with vendors to try to align security obligations, in this case, privacy obligations. So I suspect we'll see things like, we have data processing addenda for the GDPR for vendors. We're going to be seeing something similar to that under the CCPA, but it's going to be a fight out between who has the bargaining power and negotiating power in terms of indemnities and other liabilities. And right now, of course, vendors come in all shapes and sizes. You have vendors such as Amazon Web Services that doesn't give you an awful lot of leeway to negotiate contracts.
I don't think they're going to indemnify you.
No, they don't now. They don't
Right.
now.
Yeah.
But then you have smaller vendors that might be establishing a voice internet phone system or things of that sort. This is the stuff I see every day.
Do we
And of
count
course, those
here?
people, the indemnity, there's a question as to the value of the indemnity.
Yeah. Well,
So,
that
you've got to
and
step either way on that one.
And is it backed
as
by
I'm
insurance?
hearing all of this, I'm wondering, it would seem to me that an IT vendor, an MSP, would automatically be they have access into the network of their clients. Therefore, what? What you were talking about with they don't have a relationship with the client's customers, but do
Yeah,
they?
but how can a business comply with the CCPA without addressing their vendors? I mean, their
Yes.
vendors are going to be, in a lot of cases, the vendors are going to be essential to their ability to respond to requests for information and to respond to and to honor requests to delete information.
Hmm.
So, I mean, that's the point. That's not the only point, but it's one of the points in the standard provisions, standard contractual provisions of the GDPR, where the processor has to, whatever it is, the processor, the controller, the
Yeah.
flash processor has to comply with those requirements. It's a little different because then they have an independent obligation to comply with it. But I just don't. It goes to one of my first comments. I just don't see how this happens without bringing in the vendors into and making
Yeah.
that possible.
Definitely. Let's move on to the two bullets here on this slide. Both possibilities for federal preemption on the one hand, which could make CCPA moot, and then congruence with all the other privacy laws. I mean, here you're a business. Let's say you're doing business in Europe and you're doing business in the states that are listed here and all the others that might happen. How do you navigate all of that?
Well, I have an engagement letter for anyone who wants one.
Yeah.
I don't know. I mean, I can't. I'm not going to answer about arbitration because I'm not a litigator. But
Yeah.
all I can say is that there's been a good argument about whether compliance with the GDPR is compliance with the CCPA, and I think the general consensus is no, that they're not the same act. Washington, Hawaii, Connecticut, all the ones we've listed here, and the ones who probably have shown up in the 5 hours since Stan finished these slides, they're not identical. It's like the breach notification laws. I mean, what do we do when there's a breach? We go through, we take our big book of breach laws, and we walk through them and figure out, well, here's the commonalities and here are the differences. But I think it's going, listen, at a minimum, absent a consistent law, whether it be a federal law or whether it be a uniform law, I keep thinking might be possible, it's going to increase the cost for businesses to comply. Any business that does business in a lot of states is going to have a significant cost. And I think last point before I stop yakking is that I have clients that looked at their business and decided to get out of Europe because of the cost of complying with the GDPR. I said, we're just not going to go there. And it wasn't a big, it's a business decision. It's fine. It's good. May have been a good decision for them. But can a California business really opt out and say, well, I'm not going to do business in Arizona? I'm not going to go do business in Washington? I mean, that's a much harder choice.
Right.
Good point.
Well, the feds have, I think there's at least a half a dozen proposals that have come in, and they really are from both in the Senate and the House. Typically, the Republican-sponsored proposals wish to preempt state law. Many of the Democratic-sponsored proposals do not. Both, as I understand, Nancy Pelosi and Dianne Feinstein have said that they will not be in favor of laws that will preempt California's CCPA. Plus, you have to sort of imagine someone getting a law through the difficult environment in Washington today that will satisfy both parties. So I think I've certainly told my clients that you should not take comfort, or you should not be deluded into thinking that this law isn't going to come into effect, at least as strong as it is now. So I think you have to get involved in doing this. Now, I don't think I don't have many clients that have opted out of doing business in Europe. They found a way to make peace with this. The sky has not completely fallen. The compliance costs vary from company to company, so I don't think that it is an impossible task. Those that have gone through online service providers, let's say online sellers, e-commerce providers that went through a GDPR exercise, are going to find that helps them in dealing with this, because this is, at its heart, was meant to be a law that relates to the sharing of information of online businesses, particularly for behavioral advertising and other purposes of that sort. So that there's some businesses that are going to have major issues in terms of the way they do business. So my friends who are in advertising are much more concerned about this than certain other businesses. So I think it's possible to comply with that. It's just that there's a lot of uncertainty right now on what's going to finally come down.
So with that, maybe a segue then, what do you do about it? Given all the uncertainty, given all the ambiguity, given the potential costs to a company for failing to comply, and I've taken your lead and filled in this chart as you've said, but let's begin talking about it. We've got a few minutes left on this webinar. Let's get practical. Let's get real. What does a company do to, in some sense, stay out of the crosshairs or be able to effectively defend themselves should they find themselves in the crosshairs?
This is the old story, how do you eat an elephant, and the one bite at a time. But I do think that the first thing that has to happen is that, and I think this is consistent with what everyone said here, is that someone has to take responsibility. The company has to take it seriously, which means that the C-suite has to take it seriously. And the position, there are a lot of acronyms for it: the CISO, the CSO, the CIO, the CTO, whatever it might be. Whoever's going to be responsible for it has to be a true C-level executive, and someone who has policy and budgeting authority. Because unless there is someone at that level who is given the authority and the responsibility, it's just going to get thrown into the morass of it's a real problem and it's a hot potato and no one really wants to deal with it. I mean, I'm one of the guys who has to deal with it in my firm, and I don't want to deal with it, but I have to.
Yeah. Well, and we see that very consistent with the evolving understanding that responsibility for security resides in the C-suite as well. And in some sense, particularly for the smaller businesses, that security responsibility and the privacy responsibility can go hand in hand. The same people, same mechanisms, if you will. can be used for managing both of those challenges, security and privacy, simultaneously. Tim, what are your thoughts on?
Well, I think one of the biggest challenges is going to be how to respond to is not how to modify your privacy policy that's on a website or something. Those are that might be relatively simple in some instances. It's implementing the rights. You provide notice of the rights just as you do under the GDPR, but how are you going to implement the rights if a request comes in? And this is something that we discuss within law firms because you could get not just a client request, but a request from a third party as now, this is not supposed to abrogate privileges and other protections against disclosure, but what are you going to do? What is the business going to do if it gets a request? There has been a procedure in California to provide generalized information on under the so-called shine the light law, but I think that's never, at least in my experience, caused a great deal of heartache because it relates to generalized categories. Now, how are you going to respond to a request from an individual without getting additional personal information you really don't have any businesses getting, but making sure that it is the actual individual who's doing it? And then how are you going to find the material that you've collected? Those are in their GDPR, according to my European colleagues particularly, very onerous requests to comply with. So that's one of the things for businesses that have considerable amounts of information. From a small e-commerce provider, it might not be a particularly big deal, but then there are vendors that often control payment information and have pieces of this. How are you going to put into their contracts that they need to be responsive to these requests when they come in, and that they have to have an equal respect for the privacy as does what the Europeans would call a controller of the data. So I see that as, if you know this, you have the managing data privacy bullet point here. Those are the big things. If you can get a grasp, on of what you have, that will become a much easier thing to respond to.
Yeah. Tom, what do you see here as well?
Well, we're already in April. It's coming up, and it's really time to start putting together your team and educating folks as to how to respond to these requests that could be coming. What exactly, folks need to understand what these requests are, what they're required to provide, and where they're going to find the data, and so on. So it's really getting kind of late to start putting those policies together. Vendor contracts, as Tim mentioned, are absolutely critical because many businesses don't really have a lot of personal information for outward-facing consumers. It's all handled by third parties. And so that's something that we need to start getting a handle on right away as well.
Yeah. Howard, on the insurance side, I mean, there's so much here.
I don't think this is necessarily an insurance issue as it is a risk management issue. And we've seen failures in insurance, such as we talked about PF Chang's, and they didn't have the right PCI coverage. But if they would have examined, what they needed, then they could have matched that up with the correct insurance policy. And so it's about addressing emerging risk. And I think there needs to be a change in mentality to shift towards, well, I don't deal with credit cards, so this doesn't apply with me, to, oh, there's a different definition of personal information and we need to expand our scope, and this is going to be people, process, and technology. And of course, you've heard ambiguity, you've heard the term uncertainty. I'm talking about this in terms of partly cloudy, and this is a great area for insurance because it can provide a financial backstop. We know there's going to be litigation here, and so not only for your own company, but certainly if you're relying on third parties and vendors, and whatever the indemnification agreement is, you probably want them to have the appropriate insurance so that they could provide more of a financial backstop. As I've heard, no one likes a bankrupt vendor, and they come in all shapes and sizes. So, from the insurance standpoint, you have, privacy and network security coverage. Of course, you would need that. You want to look at the definitions of personally identifiable information. You want to look at your regulatory defense and fines and penalties, and make sure that's broad enough to cover foreign to domestic to state to local legislation and fines and penalties. And you may need, as far as when you analyze this from a quantitative standpoint, you might want to consider, do I have enough protection along with everything else I'm implementing to have an effective risk management approach? Because I think the biggest bang for your buck is you need to look at how are you going to avoid. We can't avoid this. This is moving forward to a different plane, whether that's going to be federal regulation, whether this is just growing pains in the legal environment. It's moving somewhere. And in a sense, it's positive because it's about protecting our own information. And I think we do need to evolve.
Yeah.
But from there, how are we going to minimize the probability? If we beyond that, how do we minimize the severity? Can we contractually transfer this risk? And then how are we going to pay for it? And that's where the insurance comes in.
Yeah. Interesting. As we're talking about this slide, I'm reminded of the metaphor of the blind men trying to describe the elephant, because we're all seeing different pieces of this somewhat differently. To me, it's that bottom left-hand bullet. If I'm a business, I want to make sure my information security practices and procedures are defendable, whatever that's going to mean, which ultimately takes us to the third bullet, the third webinar we're going to do on. In fact, let's just jump ahead to the next slide. The next two slides are all about the devil being in the detail. On the one side, what you talked about, managing data privacy, data inventory, data map, data minimization stuff, Tom. And we're going to focus on that at the next piece, where my guests are going to be Alana Bovley, who's both an attorney and a data privacy person, and David Grazer, who runs the privacy practices for a firm, Tavora. They're going to be my guests. And then the final of these is going to be on what are is there a set of minimum reasonable security practices for an organization? And we in SecureTheVillage are in fact taking the code of basic IT security management practices that we've developed a couple of years ago, recasting those to form what we believe will be a minimum set. That is to say, here's a set of things you need to do. If you're not doing these, then you have no claim that what you're doing are reasonable. So we want to, as a community, provide this. Okay, here's a baseline. You got to be doing this, or we in the community, if you will argue that what you've done is not yet reasonable. So those are the two next webinars coming up that seem to me to be to take this slide, what to do, particularly the last two bullets on the left-hand side of this, and take it down the two corresponding rabbit holes, if you will, one of managing data privacy and the other of implementing defendable information security practices and procedures. And, well, to me, it's clear that, what's reasonable for a small business, $25 million, let's say, holding some personally identifiable information, whatever that ends up meaning, is very different from AT&T, Time Warner, Facebook, etc., who are holding.
Facebook's a different story. They just don't have it. So
yeah. So, final thoughts, final words on this slide before we kind of take it home.
Well, we have immense legal talent here, and reasonable security could be looked at from the InfoSec perspective, but ultimately it's going to play out in the court. So from a legal perspective, what is defendable and reasonable security practices?
Well, reasonable is a word that is not unfamiliar in the law, and it is a word that drives, I suppose, more precise people crazy because it can have some flexibility. But this is not new territory. They've been fighting over what is reasonable security in data breach suits that have already been pending. So we're going to see probably buildup of that in terms of what that legally means. And one things that you do look to, of course, are security standards externally, but you also look to the means in which they were implemented, what the people knew, when they knew it, and what they did to comply with it. So it really becomes not just an exercise in comparing a set of standards to another set of circumstances, but a more humanistic endeavor which looks at what information was known at what time and how the human element played into that.
And I would say that a lot of, in terms of defining what's reasonable, a lot of that is going to depend on the process that it can show you. I mean, this happened in GDPR. I think that a company that shows that it did inventory and map its data, that it does consider what data it collects and minimizes that to a reasonable extent, and that it actually goes through the process, is going to more likely, not necessarily absolutely, but more likely to be considered as engaging in reasonable security steps, because they looked at it in light of their business. And that's been a consistent definition in most of the laws that touch on the reasonableness of security procedures.
Mm-hmm. Yeah, actually, just an FYI for the audience, Bob and I wrote what may have been one of the first papers ever legal that kind of looked both at the legal world and the evolving practice world. This was, I think, in 2005. Bob, you and I wrote on emerging standards of care.
Yes.
Yeah. So they're
still emerging.
And they're still emerging.
The
ever-emerging standards of care. Tom, any final last words on your piece of it before we write it out? Yeah.
Well, I'd be focused on the private right of action, the data breach portion, because that's where you can really be hammered, and take a close look at that part.
Mm-hmm. Yeah. Yeah, absolutely true. So that plays into the next two episodes of these webinars, May 2nd and June 6th. So that's kind of wraps it up. Here's our webinar series. They're the first Thursday of the month. They tie into the Secure the Village resource kit, which is online. We're just now building a CCPA piece to go with the rest of the legal resource kit. This webinar will be on that within the next several days. We'll have that done. And this is just one of the many ways that Secure the Village is all about. How do we turn people and organizations into cyber guardians? How do we help the broader community in this collective way? As you see, this is not look at it through one lens, but look at it through the risk management side. There's a legal side. There's the operational side like we do. There's the IT people, the vendors, the MSPs. We've had them on the webinars in the past. They were instrumental in helping us write the code of basic IT security management practices. This minimum set that we're now going to develop. So Secure the Village is all about turning people and organizations into cyber guardians. Contact information for all of my guests is here. I encourage the audience, any questions at all, any issues you might have about CCPA or the legal or risk and insurance side of cyber. You've got great people. Their contact information, as I say, is on this slide. Feel free to reach out to them. One of the things about all the people in Secure the Village that I'm just so grateful for is how willing you all are, how willing everybody is to give of your time and expertise to help the community understand this. On the Citadel side, we publish a free cybersecurity news of the week and weekend vulnerability and patch report. I will argue that if you're not updating and patching your systems on a regular basis, you cannot claim to have reasonable practices. That's part of that floor. We can argue that in court, perhaps. I think we'll win on that piece of it. And if you want to market, we're a great marketing venue. We've got lots of people who watch this, both in real time as now. And again, it goes on our website so that it's there forever. So if you want to market, if you want to use this as a sponsorship opportunity, certainly email us. With that, I want to thank you all. I want to thank the audience for participating, and I want to thank my guests. I mean, you guys have been great. So grateful to you for your giving of your time. And with that, we are adjourned. Thank you.
Thank you, Stan.
Thanks.
Bye.
Thanks.